Very good evening, aspirants. Welcome to the daily editorial analysis brought to you by Shankar IAS Academy. Today, 3rd August 2024. This is a list of articles that we will be discussing. The first editorial article, Governor should be a bridge between center and the state Prime Minister. It is taken from the newspaper The Hindu. This comes under the GS paper 2. And the second newspaper article, IAS officer accused of harassing judges face criminal contempt proceedings in Jammu and Kashmir High Court. This is taken from the newspaper The Indian Express and comes under GS paper 2. Without much delay, let's begin with the first article. The first article for editorial analysis is about the governor. So the article, governor should be a bridge between center and the state, Prime Minister. This article is taken from the newspaper Hindu. Let us discuss more about this article with the help of a mains question. And the question is, discuss the instances of conflict between the governor and the state government and also evaluate the judicial pronouncements in this regard. So it is a 15 marks question and you have to write around 250 words. Let us try to answer this question with some basic understanding about the governor, the role of governor and the area of conflict between the state government and the governor and certain judicial judgments relevant to this. First, we will start with the basic constitution provisions related to governor. So we know that governor is considered as a nominal head of a state and he will be appointed by the President of India under Article 155. And the term of the governor is 5 years, but he can be removed by the President under Article 156 before the 5 years. And what are the eligibilities to become the governor in India? The first one is he should be an Indian citizen and his age should not be less than 35 years. And the third major eligibility is he should not be a member of either parliament or state legislative assembly mentioned in Article 156. And the oath of affirmation will be taken by the governor before entering the office. And it is mentioned under Article 159. What are the powers of governor? The governor assumes 5 major powers. First one is executive, second one is legislative, third one judiciary powers, fourth one discretionary powers, and the fifth one financial powers. What are the executive powers assumed by the governor? He appoints the chief minister of states and other ministers on the advice of chief minister, and he appoints the advocate general of the state and also the state public service commission members, and also recommends president rule in the state under Article 356. Coming to the legislative powers, the governor summons, prorogues, dissolves the state legislatures and also grant assents to bill and also issues ordinance if there is any emergency situations. And coming to the judicial powers, the governor appoints subordinate court judges. And what are the discretionary powers of governor? He appoints the CM in scenarios when there is no clear majority in the assembly and also recommends president's rule in the state and also act without council of ministers in certain situations under Article 163. And coming to the financial power, he recommends money bill because the money bill can be introduced in the assembly only with the prior recommendation of governor in the case of state and only with the prior recommendation of president in the case of union. Now we are going to see what are the major conflict between the governor and the state government and what are the major reasons for this. First major reason is political bias, that is the political difference between the governor and the state governments. Best examples are the recent incidents of West Bengal and Maharashtra. And the second area of conflict is appointment of CM when there is no majority in the assembly, and that condition is also known as hung assembly. So here the governor will use his discretionary power to appoint chief minister. And the third major reason for the conflict is discretionary power, that is the overuse of Article 356 to impose president's rule in the state. This can also become an area of tension between the state government. And the fourth major area of conflict is a reservation of bill. This can delay the legislative procedures in the house. And the fifth major reason is the dual role. Sometimes the governors will act as constitution heads and certain governors will also act as central agent. This can raise tension between the state government and the governor. Now we are going to discuss what are the steps can be taken to resolve the tension. First we will see the judicial interventions such as SR Bommai case and Nabam Rebia cases. So this kind of judicial framework will help to reduce the tension between the governor and the state government. And the second one is implementation of recommendations of commissions such as Sarkaria Commission, Venkatachaliah Commission and Rajamannar Commission, because these commissions recommended clear framework for governor's role in the state and enhanced consultation between governor and the state government and enhanced governor's accountability to the state legislatures and also limited governor's discretionary power. This recommendation was made by the Sarkaria Commission in 1988. Now we are going to discuss what are the important judicial cases related to the conflict between the governor and the state government. The first case is Rajasthan versus Union of India 1977, in which the Supreme Court held that discretion is not absolute. Therefore, it must be exercised in accordance with the Constitution. Second major case is Hargovind Pant versus Raghukul Tilak 1979. Here the Supreme Court held that the governor's power to reserve a bill for president's assent is not absolute. And the third important case is SR Bommai versus Union of India 1994, in which the Supreme Court framed guidelines for governor's role in dismissing a state government. And the fourth major case is Rameshwar Prasad versus Union of India 2006, in which the Supreme Court held that the decision to dissolve the assembly can be challenged in the court. And the fifth important case related to this is Arunachal Pradesh versus Pratibha Singh 2020, in which the Supreme Court held that the governor's decision to advance the assembly session was unconstitutional. And the next important case is Karnataka versus Umadevi 2019, in which the Supreme Court held that the governor's decision to invite a party to form the government must be based on an objective criteria. And the last important case, Nabam Rebia versus Deputy Speaker 2016, in which the Supreme Court held that summon or prorogue the assembly is subject to judicial review. These are the important cases related to the governor versus state. With this, we are coming to the conclusion for this topic. A conflict between the governor and the state government because of political bias, discretionary powers, and procedure ambiguities may hinder the legislative as well as the governance of a state. Therefore, implementing Commission recommendations are very crucial to enhance the relationship between the state government and the governor, and also to establish smooth administration and governance. With this, we are coming to the conclusion for this topic, and let us discuss the next topic. Look at this newspaper article taken from the newspaper Indian Express. IAS officer accused of harassing judge faces criminal contempt proceedings in Jammu and Kashmir High Court. In this background, let us discuss more about the contempt of court and its proceedings with the help of a mains question. And the question is, discuss the significance of Contempt of Courts Act 1971 in maintaining the dignity of judiciary in India. It is a 15-mark question and you have to write around 250 words. And let us start the discussion with a basic question. What is contempt of court? Contempt of court refers to actions challenging or disrespecting a court's authority, justice, and the dignity. And it reflects the judicial independence, rule of law, and balance of power. It is crucial for respecting judicial decisions and maintaining system integrity. There are two types of contempts. First one is civil and the second one is criminal. Moving to the types of contempt of court, first we will discuss the civil contempt. It is a willful disobedience to a clear specific court order, and it also includes contumacious conduct, that is deliberate and stubborn contumacious conduct. For example, a refusal to pay court-ordered alimony even though a person has capacity to pay the amount. And the next type is criminal contempt. It includes undermining court authority, dignity, and respect, or actions scandalizing the courts such as damaging public confidence, interfering with the justice such as obstructing proceedings, intimidating witnesses, or disrespectful conduct within the court. Example for this, derogatory remarks about judges through any means. Now we are going to see what are the constitutional regulations related to contempt of court in India. First, we will start with Article 142 and 215, which empowers the Parliament to enact law related to the contempt of court. And second one is Article 129. This empowers the Supreme Court to punish the contempt of itself. And Article 215, it empowers the High Courts of the state to punish contempt of itself. And finally, the Contempt of Court Act 1971, which was enacted followed by the recommendations of H.N. Sanyal Committee, and it gives statutory backing to the idea and the court. Now we are going to see who issues the contempt of court. Judges and courts can issue the contempt of court when there is a non-compliance with the court order, disrespectful behavior, failure to appear before the court, refusal to testify, or actions obstructing justice, and fraudulent conduct or violating protective orders. And what are the penalties for this? Penalties includes fines, imprisonment, and other sanctions. Now we are going to see how the judges issues the contempt. The judges can issue the contempt in 5 ways. First one is contempt citation, that is a formal notice stating someone is in contempt. Second one is show cause hearing, that is hearing where an accused explains why they cannot or should not be held in contempt. And the third type, direct orders, that is immediate orders during court proceedings for disruptive behavior in the court. And the fourth one, written orders, that is a judge's written decision for reviewing a case. And the fifth one, contempt findings, that is immediate sanctions or follow-up hearings to determine penalties. And now we are going to see what are the concerns regarding the contempt of court. First one is related to the civil contempt. Non-compliance with the court orders obstruct justice and violates right. The example for this is T.N. Godavarman Tirumulpat versus Union of India, in which the state was held in contempt for failing to protect forest, impacting Article 21, right to life and personal liberty. And second one related to the criminal contempt, that is the actions that disrespect the court can erode public confidence. Example case for this is the Arundhati Roy versus Union of India, where Arundhati Roy faced contempt for derogatory remarks about the judiciary, raising issues related to Article 19, Clause 1, Subclause A, related to freedom of speech and expression. And the third major concern is misuse of contempt of powers. This raises concerns about the misuse of this authority by the judges. Example for this is Justice C.S. Karnan 2017 case where the judges' contempt raised questions about judicial accountability and potential violation of Article 19 Clause 1 Subclause A. And the fourth major concern is media's role. The media coverage can influence trials and leading to contempt charges. Example, the state of Gujarat versus Anil K. Shah 2009, where the media outlets faced contempt for pre-judicial coverage highlighting issues related to Article 19, Clause 1, Subclause A. And the fifth major concern is about the public interest activism. The activist may face contempt for criticizing judicial decisions. The example for this is Kedarnath versus State of Bihar 1962, which emphasized the good faith criticism should not lead to contempt, reinforcing protection under Article 19 Clause 1 Subclause A. And the final one, balancing judicial authority and individual rights, because it is very crucial. Example, S.P. Gupta versus Union of India 1981, where the Supreme Court examined contempt to ensure personal liberty, linking back to Article 21, right to life and personal liberty. The above cases illustrates how contempt of court significantly affect the fundamental rights and judicial authority in India. They highlight the need for careful consideration of free speech, personal liberty, and access to justice within the legal system. That's all for today's editorial analysis. And before leaving this channel, don't forget to subscribe and also hit the bell icon to receive on-time updates, and also consider like and also give your feedback as comments, and also share this content with your friends to make the competition more healthy. Thank you. Have a nice day.